Okay, thank you everyone. Today we're going to talk about fundamentals of real estate syndication, and let's jump right into it. So here's what we're going to discuss today. We're going to discuss what is real estate syndication, how do I legally do this, what documents are required to accomplish this, what types of incentives or kickers do sponsors offer to their investors, what type of fees and income do sponsors receive, and how are syndications structured. And please, I'm going to answer all of your questions at the end. Please utilize the chat box feature that you have on Zoom, and I will be sure to stay as long as necessary to answer all your questions. So real estate syndication is a direct property investment where numerous investors pool their capital to purchase the real estate. So the important thing to understand is that these investors do not have an ownership interest in the property. They will not be on a deed like in tenants in common investing. These folks will own an ownership interest or stock or some type of membership interest or partnership interest, depending upon how the structure of the transaction will be. They will have an ownership interest in the entity that owns the real estate. Now, this was extremely popular during prior to 1986, when there was a large change to the tax code. Before 1986, investing in real estate syndication was a major tax shelter, and there were many real estate agents that focused their practice on syndication of commercial real estate transactions. With the popularity of some of the changes to securities laws, which we're going to talk about during this presentation, it's become even more popular again because the amendment to Regulation D, which added Section 506C, allows sponsors and principals to utilize the social media, the internet, and a variety of technology to raise interest in these transactions. Now, a company must meet an exemption from registration under the Securities Act of 1933, which governs the sale of securities, or they'll have to conduct an IPO, which is very costly and time-consuming, and for most of these transactions does not make any sense. So just to simplify again, I want to stress that syndication does not involve the sale of real estate. It involves the sale of securities, which is stock, membership interest, or partnership interest in the entities that are going to purchase these properties. We're going to go into detail later on in this presentation on the various structures of real estate syndication. So there are two different ways to structure these syndications. Now, everything we're talking about would be an exemption from the Securities Act, which won't require the sponsor to register these offerings with any type of security interest. So ultimately, Section 504, which is the first one, governs up to $5 million within the sale of estate. So, for example, if you're offering securities only to Florida residents and you were trying to raise up to $5 million, you could avail yourself under Rule 504 exemption. The more common exemption is 506B, which, except for limited offers and regarding to it does not have any limit on dollar amounts, and you can sell these projects to investors and up to accredited investors and up to 35 unaccredited but sophisticated investors. And we're going to go in detail on what the definition of accredited investors will be. So under Rule 506B, which up until the Jobs Act of 2012 was the only way that you could raise capital, and direct solicitation by management was prohibited. Generally, you can only sell to family, friends, or friends of family and friends, or you could sell it through a licensed securities broker. these offerings, in addition to the documentation that we're going to go over during this presentation, the offerings are also subject to blue sky laws. Blue sky laws means that each state where you're offering securities to would also have separate laws. Like in certain states, you have to register offering, which can be costly, time consuming, and in many instances cost prohibitive. Now, under the Jobs Act, the prohibition on direct solicitation has changed under Rule 506C, but the only difference is, unlike under 506B, where you can sell to 35 unaccredited but sophisticated investors, under 506C you can only sell to accredited investors. So the way this comes into play would be, let's assume that you're buying an apartment building for $1 million, and you can get a loan for $750,000. So that 25% equity, that would be the $250,000 would be what you would syndicate. So you would actually sell shares in the entity that is going to be purchasing the property, and in return for the $250,000, the outside investors would receive certain interest in the profits of the company, or some other benefits, which we're going to go over a little later. So I've given you in this slide a breakdown of the more common sections of the accredited investor definition. So generally, most of the investors that you are going to be seeking in your projects will fall under one of these three categories. A natural person or joint net worth with that person's spouse that exceeds $1 million, but does not include the person's primary residence or mortgage thereon. So these are high net worth individuals. That's what generally accredited investors will be. Or any natural person that has an individual income in excess of $200,000 in each of the 2 most recent years, or joint income with their spouse in excess of $300,000, or reasonable expectation, which that's the key, of reaching the same income level in the current year. Now, that a lot of folks may be affected based on the fact that, as a result of COVID, a lot of folks' income, at least in the short term, are not projecting high. Or lastly, any entity which all of the owners are accredited investors. So under 506C, you can only sell securities to accredited investors. And we're going to talk about what the differences are between 506B, which is the traditional way of raising, of conducting these real estate syndication transactions, and 506C. So Regulation D, that is the regulation that Rule 506B and 506C talk about. But traditionally, until 2012, companies wishing to sell private securities had to rely on friends, family, or their own networks, because securities laws did not allow for general solicitation, other than if you used a licensed broker. And this all changed in 2013 when the Jobs Act came into effect. So the Jobs Act broke the Rule 506 exemption into 2 parts. 506B, which was the old approach, and 506C, which allowed investors to utilize social media, the internet, radio, TV, podcasts, which is what a lot of real estate syndicators use these days, Facebook groups, LinkedIn groups, in-person dog and pony shows, as we like to call it, where oftentimes there's, and we have that a lot where I am in South Florida, where sponsors will rent out a restaurant and provide free lunch or dinner to prospective investors. And I've gone to some of those before, and they've been at some really nice restaurants. I've been to a couple at Morton's in Boca, and it's Boca Raton, which is an excellent restaurant. So we're going to go now into the other key differences between these 2 rules. So we talked about that they have the ability to solicit anyone, including roadshows or any other media. Now, in Rule 506B, investors are allowed to self-verify. So generally what we do is we have an investor fill out an investor verification letter and a subscription agreement, and we have a suitability questionnaire, which basically has a prospective investor certify that they meet one of the definitions of accredited investor, or if they're one of those 35 unaccredited investors, that they meet the definition of sophisticated investor, which generally is a very broad definition. And what I normally recommend to my clients, if at all possible, is only sell your offerings to accredited investors. Because generally speaking, the definition of sophisticated investors is so broad, and generally the sophisticated investors are the ones that generally will sue you in the event that the transaction goes bad. And let's just take a step back. The whole reason for all this regulation is that the Securities and Exchange Commission, under the Securities Act of 1933, is set up to protect these small individual investors. And so generally thought, because these real estate syndication transactions, there's no public market for them. You can't go and sell your shares in ABC Apartments LLC on the stock market because there's no market for it. So the thought is that the SEC says if somebody meets the definition of accredited investors, then they understand and appreciate the risk. The problem is that the no action letters, which is what the SEC publishes in their guidance rulings and their enforcement proceedings, the rulings are all over the place as it relates to what is and what is not a proper definition of sophisticated investors. So that's why I generally recommend to my clients, as I mentioned earlier, only sell these offerings to sophisticated investors. Now, under 506C, the issuer, its advisors, must take reasonable steps to verify the accredited investor status of each investor. So if for some reason the sponsor makes a mistake on it, they're the ones that will be liable for a prospective investor not meeting the definition of accredited investors. The good news is, with the advent of technology, there's a variety of service providers that will do these verifications of whether or not an investor is an accredited investor. And I list in the slide below what reasonable steps requirements. So a third-party verifier, and I gave you an example, verifyinvestor.com, and I'm not, keep in mind that was just an example. I'm not trying to recommend, or nor do I receive any compensation for verifyinvestor.com. For making that example and providing the URL for that. Additionally, these both the 506B and the 506C are also subject to blue sky laws. For example, you have to pay a fee or register in each state. Now, there's a uniform blue sky application that you can file in the area where you're soliciting investors. So the key is, how do you know which states you're subject to under blue sky laws? The key is that it is not where you communicate, because most of the time you're either communicating over the telephone, internet, or sometimes in person. It's actually where the investor is located. So for example, if you're seeking investment from folks in New York, then you are subject to the blue sky laws in New York if those investors live in New York. Also, if you have a road show, a dog and pony show as I call it, in Florida and the investors are from New York, you would be subject to both the New York blue sky laws as well as the Florida blue sky laws. Now keep in mind, the failure to follow any of these guidelines that we are discussing today would subject you as the sponsor to potential civil enforcement action, which would be penalties, a return of all your investments, and if you have a license with FINRA, You will potentially also lose your license with FINRA. And you could also potentially, if you have a real estate license, you could lose your real estate license. And then if it becomes some type of Ponzi scheme or other scheme to defraud, you could also be subject to criminal penalties. And it'll be just like that scene at the end of Wall Street where Charlie Sheen is hauled off in handcuffs. And you don't want to be that person, trust me. That's why I'm so happy that all of you are here attending live and in person, and ultimately you'll be watching this video, the recorded webinar that we're providing. Again, you aren't the folks that I'm worried about. I'm worried about all the other folks that are making their own rules and not following the law as it is written right now. So what legal documents will you need? And these are all legal documents that our firm provides for you. An offering memorandum. This is going to be analogous, though not as much detail as a prospectus for a stock offering or any type of disclosure documents for mutual funds. Basically, what it's going to provide, and I'll tailor make this to a particular offering. So let's assume that, using our previous example, that you are going to purchase a $1 million apartment building. So generally what you would do is you would provide the projections for that particular apartment building. You'd provide the market statistics for the particular area where you are purchasing that property. You'll provide all of the details of that apartment building. You would also provide all of the risk factors for folks investing both in that particular area as well as nationally, what the risk factors are investing in apartment buildings, and also the risk factors that would be involved in investing in illiquid securities as well. You would also document what the sponsor's experience is. You provide a bio. You would also provide, if possible, past success that the sponsor has had. Like, for example, if the sponsor has syndicated 3 other apartment buildings in the past, you would provide case studies on the successes of those apartment buildings. Now, don't be discouraged because oftentimes, if you're working on your first project, really what you would provide is your bio and your experience in the real estate industry and in the investment industry. And generally, this type of offering disclosure is anywhere from 15 to 30 or 40 pages. And it will also include all of these other documents as exhibits to the offering memorandum. Now, depending upon which state you file you're seeking investors in, you also may have to file blue sky filings. Additionally, there's one document that you have to file with the Securities and Exchange Commission. It's called a Form D. And that basically just outlines the offering, which states you're going to be offering, the amount of securities that you're going to be selling. Also, you would have a subscription agreement. That's the actual document that the investor signs where they say, I am going to invest $500,000 in the project. In exchange, I'm going to get a certain percentage, shares, ownership, partnership interest, membership interest, depending upon how the investment is structured. You'll also attach to the offering memorandum the actual formation documents of the entity. You have to assure before you can start the syndication process that you have an actual entity that's filed with the state where the property is located. Like, for example, if it's a corporation, it would be an articles of incorporation. If it's a limited liability company, it would be an articles of organization. Or if it's a limited partnership, it would be a certificate of limited partnership. Now, I just want to stress, certain states favor different entities over others. The traditional model for many years was that these types of real estate syndications would be in the form of a limited partnership. And the more modern version in many states is that the limited liability company is the preferred method of syndication, but it's really a state-by-state analysis. And certain investors feel more comfortable in one structure over the other. And then you would also attach the shareholders agreement for corporations. If it's an LLC, the operating agreement. If it's a limited partnership, it would be a partnership agreement. And this really is the meat and potatoes of the legal document that your folks are investing in. It will govern the operation of these entities. It will also, most importantly, spell out the different fees that you as a sponsor will get. And we're going to talk about those in more detail. And then the last document would be the investor verification letter. And that is the key to that is if it's a 506B, then the investor will self-verify. And if it's a 506C, you generally, I can only recommend representing a sponsor that you utilize an outside verification service to certify that for you. Now let's talk about how these transactions are structured from a business standpoint. So let me just start from a basic understanding. So generally what you will do to purchase these properties is you'll have a mix of equity raising and debt. And so what I mean by that is that, in using the example that we talked about earlier, if you're purchasing a $1 million apartment building, and generally lenders will lend anywhere from 75% to 80% of the loan to value to acquire the property, you generally want to bridge the gap between the loan. So in my prior example, your $750,000 loan and the $250,000 plus closing costs that you'll need to close on the acquisition of the apartment building. So generally what you would do is you would have an equity raise, and there's different ways you can structure it. You could sell common shares, which would be that you could potentially sell off, the 25% of the company in exchange for the 25% interest in the company, which would equate to $250,000 and maybe a little more for closing costs. And then they would share in the profits. And depending upon especially if you're a newer investor, you as a sponsor would retain a small ownership of the company, but then you would have various fees, and you would also have profit participation, which the general profit participation as a sponsor would be 20% of the income of the property. Another way you can structure it, and this is how a lot of my more experienced clients structure it, is instead of giving them common shares, you'll give them preferred shares, which would mean that they would be guaranteed a preferred annual return, plus they would also receive a priority, meaning that any money that comes in after expenses would go to pay the preferred return. And so generally a preferred return and it really just depends upon the market, the experience of the sponsor, as well as the market and the current state of the economy. Generally a preferred return would be anywhere from 8% to 15%. And generally when you're offering these to outside investors, you want to guarantee them a higher return than the stock market is. And this year especially, the stock market is on a wild roller coaster ride. And so that's really what you always want to offer to outside investors, would be the preferred return that would exceed the stock market, or at the minimum, what interest in a bank account would be. And with the low interest rates that we have right now, it certainly would be that, it would certainly be a very low rate based on interest. Savings accounts and money markets are paying at the most 2% and oftentimes well under 1%. And then the important thing to understand when you're structuring these syndications is the operating agreement will spell out what the waterfall distributions will mean. And what that means is it's the order of priority on how the partners in the entity, will get paid. And that gets to be very, very detailed. And so I just want to give you a basic overview in this particular seminar, because we're just talking about fundamentals. So then the next step would be what your debt stack would be. And generally, you would get a first mortgage secured by real estate, and you also could get a mezzanine loan, which is secured by 100% pledge in the shares of the entity, plus the second mortgage, and it's a very, very high interest rate. So sometimes what you'll do in larger transactions is you would raise equity. You would also get a first mortgage, which would sometimes be as low as 65 to 70%. And then you would get a mezzanine loan up to 90% at loan to cost. And those would be secured by a pledge in the shares. And generally the blended rate, so let's assume you would get an interest, you would get a first mortgage with an interest rate of around 3 to 4%. The mezz loan would be 9 to 10%. And then depending upon whether or not you're raising selling common shares or preferred shares, that would also spell out what the stack would be. And then the operating agreement would also spell out you as a sponsor, how you're compensated. You would get acquisition fees. Sometimes it's 1 to 2% of the purchase price. Property annual management fees, which could be 1 to 2%. You would get oftentimes get a 20% profit participation. And then also, if you are doing ground up construction, you could also get a construction management fee of 1 to 2% of the purchase price. So how can you profit for this? I think we've already discussed it. This real estate syndication provides a way to fund your own deals. You can be compensated as a finder or sponsor. It allows increased access to mortgage financing, and it also allows small investors to invest in larger real estate projects, either as a lender, a partner, or both. So here's a couple of different structures. So the equity syndication structure would be that you as a sponsor would have an entity. You would bring in your outside investors, and both of you would own the acquisition entity, and then you would purchase the property through the acquisition entity. Another structure is bringing in outside investors as your lender. So the outside investor entity, you'd basically syndicate an entity that would provide you a loan to the acquisition entity, which you would own in its entirety or a majority portion of it. And then basically the outside investors would give you a loan to purchase the property. So we have about 8 minutes left. So now I'm going to open up the floor to questions and answers. So I've got a couple different questions. So the first question is, how is this different than a REIT? And it's different than a REIT because a REIT is most of the time they're publicly traded. So generally, if you invest in a REIT, and generally a REIT is not just for one property, it's a pooled investment to purchase multiple properties, generally over a similar asset class, following a certain investment strategy. And REITs are publicly traded. So if you buy a share in a REIT, then you can go through your broker or online brokers. There is a ready market. Those are liquid investments. A real estate syndication, these are the sale of private securities, and there's no market for them. The next question is, formally to sell shares in a REIT, a person needed a FINRA Series 7 or 39. Has this changed to allow real estate licensees to transactions, not only the real estate and syndication, but to sell actual security shares to qualified investors? That's an excellent question. So certain states will allow, like for example, California has an exemption which allows real estate agents to be compensated for commission for the sale of syndicated shares, like the examples that we are illustrating. Florida does not have that same exemption, and New York does not have that same exemption. So generally, a licensee, if it's a real estate licensee, the only way they can be compensated would be to get their Series 7 or Series 39. Now, the one thing I can tell you as a sponsor, like for example, if you are selling your own deal, you can receive compensation, i.e. shares in the profits of the entity or other types of fees as we illustrated for being a sponsor in a syndication. But if you are just acting as a real estate agent and you are putting folks together and you don't have any interest in the company, then you cannot receive any compensation under many state laws. So there was a comment on Morton's in Aventura and the Morton's in downtown Miami. I haven't been to those in a very long time. I've been to the one in Boca about a year ago and it was pretty good. So we'll leave it at that, but we can have another seminar just on comments on local restaurant establishments. Next question is, how popular is syndication today under the current tax code? Syndication is extremely popular right now, although it doesn't have the tax benefits as it used to, especially with the advent of 506C and social media and the opportunities and the creativity of those that are raising capital. Syndication is extremely popular. I've been an attorney for 20 years now, and ever since I've been licensed as an attorney, I've been working on these. It's very popular in certain states. I first started practicing in Texas and it was extremely popular. And then I moved to Florida and I was a corporate securities lawyer like I was in Texas. And every deal that I worked on was a real estate syndication transaction from a corporate standpoint. So these are very popular and there's a variety of different techniques that you can use, and it's really a great way to get small investors investing in real estate. And it's, I can't stress enough what a great tool this is for folks. The last question that I have, and please, we have some time, so please feel free and ask any questions. Should language be included in any real estate contract as to whether COVID-19 is force majeure? I would definitely recommend that anytime, especially during this time frame, that you would specifically spell out COVID-19 is a force majeure, which under force majeure is Latin for act of God. And most of my practice right now has to do with the fallout of transactions as a result of COVID-19. And certain real estate associations have their standard COVID-19. Like I know, for example, Florida has their standard COVID-19 addendum, and I certainly would recommend that that you include that in all real estate contracts. Did you guys have any other questions? Do advertised prohibitions apply to joint ventures? Excellent question. So that it's kind of a gray area. Generally speaking, you just have to be careful because we have to apply the analysis conservatively, because the whole thought process behind these SEC rules is consumer protection. Now, what I would say to you is, and this is what I mentioned earlier on in the presentation, was that you always want to err on the side of being conservative. That's why I always recommend that you syndicate only to accredited investors. The 506B rule, which allows 35 unaccredited but sophisticated investors, those are the folks, those 35 unaccredited investors are the ones that are going to sue you. And the SEC guidance on whether or not these advertised prohibitions apply to JVs are all over the board. Well, I thank you all for taking time out of your day and spending time with me. And I just want to let you know that we are going to have educational webinars every 2 weeks, and I will definitely keep you all in mind and send you notification of these future educational opportunities. Thank you. Be safe. And I'll leave you with a couple slides on the Wallace Law Group.